Thank you so much for meeting with us, Bill. Can you just tell me first name, last name, and what you do? What's your experience in open meetings?
My name is Bill Ailshire. I'm a practicing attorney in Austin, Texas, and I focus my law practice on government transparency and accountability.
Perfect. So today we are talking about some issues that I'm bringing to you with the city of Taft. Specifically, let's start with their posted agendas, right? So in terms of the Open Meeting Act, they do allow for citizen comment. But their citizen comment, they say comments can only be on the subject matter. Sorry, they are for items on the agenda. And if there are more than 5 people who wish to speak on the same agenda item, then they must select a representative. Can you go into the potential concerns about this item?
In 2019, the Texas legislature adopted a provision in the Open Meetings Act that requires governmental bodies to, quote, allow each member of the public who desires to address the body regarding an item on the agenda for an open meeting of the body to address the body regarding the item at the meeting before or during the body's consideration of the item. So that violates the idea that if there's X number of people that want to testify, you're going to deny 4 of them, 4 members of the public would be denied their statutory right to address it. And so I think that is pretty clear violation of the public testimony provision of the Open Meetings Act.
The other thing that we were talking about is whether any governmental body can limit people from speaking on really anything that they want to speak on. I know that that's come up not only in Taft, but also the Corpus Christi. So delve into that a little bit for me.
Yeah, before this amendment to the Open Meetings Act, there was no law as such that required a governmental body to let people speak unless it was in a formal statutory public hearing, like a zoning case or a public hearing on the budget or tax rate. Just their normal routine meetings, they're not required to allow anyone to testify at all. Now they have adopted this statute requiring governmental bodies to let any member of the public speak on an item that's on the agenda. Most governmental bodies have for many years had what we call citizens communication. And I spent 12 years as Travis County judge, head of the commissioner's court, running meetings all the time. And we allowed people to come in and address issues that relate to county government, but were not necessarily items on the agenda. And they could speak to us and we could listen and we could consider whether or not to put that subject matter on the agenda in the future. But we allowed them to speak. And most governmental bodies do that. I am surprised to hear that the city of Taft doesn't allow that at all. And that the only time anyone can speak during a meeting to their elected representatives is if somebody has put an item on the agenda. That means, for example, if somebody wants to come down there and say, you don't have this issue about X, Y, or Z on your agenda now, but I sure wish you would put it on a future agenda. They can't make that testimony. That's undemocratic. Now, the only legal issue that could bring up is that the Texas Constitution, as part of free speech under the Texas Constitution, has what we call a right of remonstrance. That is the right to complain to your government. And the government is required to stop, look, and listen to that complaint. So if somebody's got a complaint they want to make, they're entitled by the Constitution of Texas to come down there and make that complaint, whether it's on the agenda or not. And so they could be running afoul of that Texas constitutional provision for free speech, basically. The other problem that raises is that since they control the agenda, there is a possibility that they only allow certain viewpoints to be heard, and that could involve free speech rights as well.
While we're on the topic of public comment, something that I learned just in speaking with you earlier is that there is currently an injunction in Austin, right? Austin City Council. Talk to me a little bit about that injunction and, essentially if I want to speak on 4 agenda items, but I'm only given 3 minutes total, how that may violate my rights.
Now, the city of Austin has rules for citizens communication that have now been challenged in court by a colleague of mine, a really good lawyer named Bill Bunch. Bill is head of an environmental organization here, and he went down at a meeting a month or 2 ago, and Mayor Watson told him that he was going to have 2 minutes. But he said, look, there's 4 agenda items that we have on here that are of concern to our organization. I want to be able to speak on each one of them. And he said, you can speak on all of them, but you're only going to have 2 minutes for all 4 items. And so he sued and pointed out that under the city charter, the rules for the procedure of their meetings are supposed to be adopted by ordinance, and they hadn't done that. The rules he was following are sort of made up, and they were only adopted by council as a resolution, not as an ordinance. And he's managed to get an injunction against them. Now everybody that approaches the Austin City Council is entitled to speak on each item, and they each get 3 minutes. And so that is going to trial in July. And I am really glad to finally see a lawsuit on the books against this kind of unreasonable undermining of Section 551.007, the Open Meetings Act. You've got bad attitudes on the part of some governmental officials that are really trying to undermine a clear right of people to speak on each agenda item. And it says that in that provision that the governmental body can adopt reasonable rules. And it says, including rules that limit the total amount of time that a member of the public may address the body on a given item. It does not say that they can put a cap on the total amount of time somebody can speak if they've got more than one item they want to speak on. The other thing to keep in mind about that new provision is they were reacting to governmental bodies that wouldn't allow people to make any complaint about staff or the elected officials. If they came down to comment, they could only say nice things about them. But they included a provision that says a governmental body may not prohibit public criticism of the governmental body, including criticism of any act, omission, policy, procedure, program, or service. And now they can't come down and defame people, but the whole point, the legislature realized that we've got governmental bodies that are being very undemocratic. And they wanted to help put a stop to that.
Excellent. That's really helpful information for our viewers. I would like to move on to an agenda that was for a meeting scheduled on March 26th of this year. And in this agenda, if you have a copy of that agenda, the closed session items include evaluation of the city secretary, discussion with staff, duties of the chief of police, and the public works director. Talk to me a little bit about how this agenda item as it relates to executive session is just not legal.
They can meet in executive session to deliberate the appointment, employment, evaluation, assignment, duties, discipline, or dismissal of a public officer or employee, or to hear complaints or charges against the officer or employee. Now, depending on what the nature of that is, they may have to be more specific. If there's a particular officer involved, they can't just say personnel matters we're going to go into executive session and talk about personnel matters. And where they run afoul of the notice requirement in the act is this portion that says they're going to have discussion with staff. That is not, first of all, you can't just have general discussion with staff. You can have a discussion of complaints or charges or their duties and that kind of thing, but just the broad topic of discussion with staff. You can have discussion with staff in an open meeting, but if you still haven't said what the subject would be, so that violate the Open Meetings Act requires their meeting notice to say what subject they're considering. Discussion with staff is not a subject. The other thing about this is they posted that item for executive session under both sections of the personnel exception, including to hear complaints or charges. If they did not tell the police chief that that's what they were going to be doing with him in executive session, then they violated the act, because any employee who is subject of a complaint or deliberation can ask for that discussion to occur in public. And then the governmental body has no legal excuse for having that personnel discussion in executive session. Now, they can still get attorney's advice, but they're limited. They can't sit there and talk among themselves with the attorney sitting there like a potted plant and really violate the open meetings requirement. They have to have that kind of discussion out in public.
Excellent. Let's move on to a document that was handed to our chief investigative reporter. And that document was, it looks like the ordinance was established initially in 2005, amended in 2009, and it establishes rules for use of equipment during an open meeting of a governmental body. You have a copy of it. What are some of your concerns with the ordinance that was put in place?
Well, a couple of concerns. The Open Meetings Act, Section 551.023, gives a person in attendance the right to record all or any part of the open meeting with a recorder, a video camera, or other means. And again, it allows the governmental body to adopt reasonable rules about the location of the recording equipment and the manner in which the recording is conducted. That rule says, for example, that they can't include a recording of people that may be in the audience. I don't see any legal basis for that. That's an open meeting. They can record the entire meeting. It doesn't say they can. It says they can record all or any part of the open meeting. It doesn't say they can record the governmental body only. The meeting is with the public as well. So that's one. The other issue about, and then related to that, is if they're going to require people to be at the back of the room to make the recording, their audio equipment ought to be good enough that if you're just using a recording, that you can still pick up what's being said in the meeting. Otherwise, by moving someone back there with just a regular recorder, if they're not able to pick it up, then they're not allowing them to make the recording. And again, from the video standpoint, if you're to the back of the room, how are you not going to record the public that's sitting in front of you and between you and the governmental body? So once again, this is it seems like maybe the Austin City Council, Freudian slip. It seems like the City Council of Taft is somewhat at war with the Open Meetings Act. You put all of this together and you look and you wonder about the underlying attitude of people who are elected officials and seem to have forgotten that they don't own that government. The public does. It's the public's government. And the public is entitled to a level of transparency and respect for their role in government. And it's not a dictatorship. people are entitled to be involved. And when you put all of these examples together, it just seems to be that they have a level of disdain for the spirit, if not the actual law of the Open Meetings Act.
Well, and ultimately, when I look specifically at this document and it says any citizen, because really the Open Meetings Act is for citizens as well, not just media, who wants to use any audio or video recording equipment has to register his name, address, and telephone number with staff prior to the commencement of the meeting. What are the problems with this?
I don't see a thing in this that says that would be a reasonable rule. For one thing, people should be able to come to a meeting, just like, and there's free speech cases out there that say people are not required to identify themselves unless there's a good government reason for doing so. You know, if you've been stopped by a police officer, you're going to have to identify yourself. That's different. But you're just attending a meeting and you want to make a recording of it, there is no reasonable basis for requiring someone to identify themselves, and particularly not to divulge their home address. There are security concerns in this day and age. It's sad to say, but you know, you're starting to make public record of somebody went down there and criticized some politician. Other people didn't like it, so they're going to find out where that person lives. That's again, there's no good basis, governmental reason to have that kind of requirement. Again, you just, what kind of attitude is there by public officials that would even think to require that? There's no legal basis for it. It doesn't say that in the statute, that that's a condition that would be placed on someone. They're adding a condition for someone to exercise their right to make a recording. They're adding that as a condition. And that wouldn't have anything to do with where the recording equipment was located or the manner in which the recording is confirmed. So I think that's another violation of the Open Meetings Act.
Well, and ultimately, the penalty for disregarding these rules is a misdemeanor with a fine not exceeding $300 for each offense.
I hope I don't practice criminal defense, so if someone does get charged with that, I hope the criminal defense attorney will give me a call. I'd be glad to try to help them with the defense that criminal, especially making it a criminal statute to exercise your statutory right. I mean, that by adding criminality on top of it, they really are going over the cliff.
What is your advice to the elected officials in Taft and to the city staff, the city attorney, to kind of fix these issues?
Think a little deeper about what your role is. I spent 12 years as Travis County judge in the Commissioner's Court here in Austin, and had to conduct those meetings. And there are a lot of times when people came down and said things that were hurtful, and you know, you feel like maybe it's unfair getting criticism. And of course, there's always times when people have something nice to say too. That's fine. But you know, I had to learn the patience to realize this is their government. Whether I think they're right or not, they have a right to be there and they have a right to speak. So my advice to them is take a step back, take a look at these laws and see whether or not they really reflect the attitude you have about your constituents and democracy and their right to be involved and to be able to exercise their rights under the Open Meetings Act. Otherwise, I could see how they could end up in court.
Excellent. Thank you so much for taking the time to talk with us. Did you have anything else you wanted to add?
Now, in these days and times, if we're going to earn trust, if we're going to have citizens trust their government, and the government earns their trust, transparency is key to it, and an openness by the government to hear all kinds of views, including the ones they don't like. And so I just think it goes to the heart of who we are as an American democracy.
Excellent. Thank you so much.
You're welcome.